Let me tell you a bit about the type of research that we have been doing at Kleros regarding the use of AI in the resolution process. So the very first time we actually tested Kleros in the real world was with a pilot we called Dodges on Trial. It was basically a test where people could send images about a Dodge, the internet meme, and people and jurors had to decide if that image was from a Dodge or something else, right? And they could earn a small reward each time one of the images they sent was accepted into the list as a Dodge. And the big jackpot was if you could kind of somehow fool the jurors to let them accept a cat image as if it was a Dodge, okay? You could make quite some amount of money. $12,000 was 50 ETH. That's a lot more now, but it was a lot of money. And you can see here a list of the images that people sent and that were rightfully accepted as Doges into the list. And these were some attempts of people who sent what they thought was a cat, but failed to pass. And people were photoshopping stuff and all that. So after the pilot ended, we did some analysis of AI and like pattern recognition to see, okay, this was done by humans, but what could AI be used for making this decision of this is a Dodge or not a Dodge or a cat? 97% of the times, the precision, that was the precision. So 97% of the time, yes. But there were a few cases that were interesting in the sense of what are the limits of AI in making these types of decisions. So someone sent this image saying that it was like a cat. I don't know, what do you think it is? Who says it's a dog or a cat? Well, it's hard because you could make both arguments and the AI failed to recognize this image. So the policy used to say that the image were to be accepted and the payout had to be done if the image clearly showed a cat. And the guy who sent this image sent me later another image asking me, hey, Federico, pay me my $12,000 because this is another picture of the image I sent. And I replied, yeah, it could be that, but what if it was actually this, right? Because it could be also a dog. So what do you think happened?
Dispute.
Of course, there was a dispute between Kleros and Ricky, that was the name of the guy, for a 50 Ether trial. And he claiming, okay, this is a cat, pay me my money. And we saying, no, it's not a cat, it's not clear. So we won by 2-1. And this is the first time also we started to think about how this collective intelligence and artificial intelligence could, interact in dispute resolution. And see, this was in 2019, way before AI was cool, so we were already thinking about these things. And we developed this hypothesis of how we think the legal system is going to evolve in the future. So for more like simple objective cases, small, lower value, maybe AI is just going to resolve them. This is more efficient, it's faster, it's almost immediate, so all good. Then there's some cases that are still kind of low value, but a bit more complex, which involve understanding emotions of parties, understanding the intentions behind an agreement between parties. This is where we think decentralized justice systems using the humans will be more, better fit for this. And then for more complex cases involving like human, like legal reasoning, moral decision making, traditional courts are still going to be better for that. So this is how we imagine the industry will evolve, and this is our hypothesis since 2019. This is behind also a bit this idea between like a development that was done by Rob here, Harmony. This is a bot that detects potential copyright infringement, but where it is not so clear whether there was an infringement or not. Maybe it was a fair use of the image or not. So this can give you, okay, this can flag potential infringements, and then you go to a panel of humans to make the final decision, right? So this is a way in which these technologies can interact, okay? Another way in which AI is affecting the use of decentralized justice is seeing AI as a lawyer, kind of. One of the companies that uses the Kleros services is called Lemon. It's a cryptocurrency exchange or a fintech company, and they have like disputes regarding unrecognized credit card transaction errors. So people asking for reimbursement of things to the company. This is how the resolution process works, in the traditional world. There is an incident, there is a claim to customer service evaluates the claim, sometimes says yes. When it says no, well, the customer typically goes to small claims court or to criticize the company on Twitter or whatever. What happens is that this is very long and frustrating, and people don't do it. People just drop out and go to the competitor, especially because these are kind of small claims. Yeah, we'll let you finish the photo. Yeah. So what happened is that we implemented Kleros in this customer evaluation process where the user goes to the company evaluates it, says no, and instead of just finishing there, they offer the customer the possibility of going to a neutral third-party Kleros trial to make a decision. Sometimes the user wins, sometimes they lose. And what happens is the following. If the user wins the case against the company, then the company will reimburse him what he's asking for. If the customer loses, he can still go to small claims court. It doesn't take any right of access to justice from the person. And when we started this, so what happened? People would make their claim and maybe make like a two-line explanation of what happened, give me my money back, you crooks. Of course, that was not the best way to present your case in court. So, but they didn't say that, but it was very short and not very clear what they were asking for. So what we started doing is ask basically ChatGPT, okay, you have this customer with this claim, please improve it, make it more clear, make it longer. And then it was like a two-page, very clear explanation of what happened in good English or Spanish because this is in Argentina. But what we saw is that before using this AI tool, the company was winning like 95% of the cases. So users, they didn't trust the system because they were like seeing that they lost all the time or almost all the time. And with this, the win and lose thing between company and customer started to be like 50% each. This increased a lot the legitimacy of the process, and now it's working. And this is how AI is contributing, like basically as a lawyer, helping the user present their claims in a better way. Okay, so this is another way in which AI helps, basically with the onboarding of cases and assistance of users, and this results in very, very high satisfaction. So you go from 80% of users being just pissed at the company and leaving the company for the competitor to a case where 90% of those who actually lose their case in this mini trial, they stay as customers because they see that they had their day in court, if you want, okay? So, and this was really a great metric to see because we are typically not thinking of, when we do all of the research, we are thinking of accuracy, attack resistance, but we don't think that much about user satisfaction with the process, which is what we learned with this particular use case of consumers. And finally, there is, of course, the rise of AI agents. That is something that we are also researching. This is a video of me speaking in an interview in it was almost 10 years ago.
Lots of the things we're going to do in the future will be in virtual reality worlds. My avatar could sue your avatar on this kingdom of virtual reality, and there would be a jury to decide who is right. The jury, we didn't define if it is human or not human. It could be perfectly robots, and the defendant could also be robots. Maybe one robot could sue another robot because he didn't do some job well, and maybe the judge go to trial, and other algorithms made of robots could settle the case. So robots and VR are within the limits of possibility from here to 10 or 20 years.
Well, I mean, when I said this in 2015, I think it did sound like a crazy thing. But 10 years from then, it's like 2025. So this is starting to come. So this is how long we have been thinking. This was even before Kleros. This is how long we have been thinking about these things. So after all of the AI agent starts, I mean, I said I'm Argentinian, so most important thing for us is football, as you know. So it was the World Cup in Russia 2018, and we said, okay, can you use Kleros to make like decisions, like referee type of decisions in a football game? It's kind of the VAR, but in the VAR you have like 4 guys making this. What if you have the audience, becoming the VAR judges, deciding whether some, plays a penalty or not? So we did a bunch of experiments. Let's see if this works, and we can have AIs make these types of decisions. I know. I mean, who remembers about this? Very, very famous disallowed goal. Anyone remembers about this? Yeah. Okay. This is what happened. I mean, should Lampard's shot be considered a valid goal? Okay. Let's see. What do you think? What do you think? Should be a valid goal? Yeah. I mean, this is pretty obvious. So we had the AIs see the video, decide, and all of the votes were like yes. Okay. So, and they gave justifications on why they thought that the decision should be yes. Okay, this is one of them, and they explained that the replays show it. More justification from the second one. So it's very reasonable. And if I didn't tell you these were AIs, you would probably not know that. Okay. Okay. Let's go to a bit of a more complicated one. So I am sure that I think that Michael is German, so he might remember this one. Any German in the audience? No. Yeah. I didn't see you. Did you remember this one? Okay. What do you think? This was a foul warranting disciplinary action or not? Because this cost us the World Cup. Oh. What do you think, Michael?
It's only fair.
Okay, let's see what the AI say. Okay, and here is more interesting because the AIs didn't agree between them. Two AIs said that it was not a foul, and one AI said it was a foul. So this is super interesting because we are seeing that different, depending on what model you use, you can have different decisions, and even the justifications also make a lot of sense. And you can see all of this information is public. So just to show you that this is how, excessive force, it was excessive force, by the way. Okay, but so for you to see how this can evolve in the future, you can have like these AI agents making decisions that are almost like instant. One of the big questions is, do you want to have one AI tool make the decisions, or would you want to have more than one? Because you can see that they arrive at different, decisions depending on who knows what data they use to be trained. Well, this is what we are trying to figure out. So what we imagine that's going to happen in the mechanism designs of the future, you could have maybe a first round of bots making a decision, and the first decision that about a case could be full of bots, just bot court. Then you could go to a court that is based on the pure economic incentives of Kleros, with anonymous jurors and staking and all that. And then maybe you could have a verified human court for a next round of appeal. Or in different order. But this is how we are thinking that this could evolve in the future, and how you make the decisions for a lot of these cases, and how AI is going to impact. Okay. If you want to learn a bit more about this, I also recommend this article I wrote at the American Bar Association as a guest writer, where I also speak a bit about the risks of AI. I didn't put this in the presentation because it would be too long already, but yeah, this is something that we have been discussing for a long time and researching for a long time. So what we think is basically there's going to be division of labor, like simpler cases for AI, more complex for Kleros or other more complex systems. Then collaboration with humans. The AI as a lawyer can also help make decisions. And then probably panel of humans responding and making a decision when people appeal to an AI ruling. So thank you very much. Yeah, let's go for it, Eric. Yeah.
Sure. It's a PDF.
Yeah. Okay.
So, real pleasure to be here. And you may notice I don't have a name tag. It fell off at lunch. And I should have known better because effectively, this suit fabric is terrible for these types of sticky name tags. I show up downstairs, the person who checked me in this morning is nowhere to be seen, and I'm like, I'm literally talking in 3 minutes, I've got to get there. Fortunately, there was a human attendant who was able to say, where are you, what are you doing, what can I help you with? And I got this sticker that enabled me to enter the building in short order. And so for me, having a recursive failsafe in most complex human-engineered systems is effectively ubiquitous. Circuit breakers, failsafes, overrides, kill switches, they all derive from the need to create a recursive fallback mechanism to shut the thing down, a big red button as it's called in nuclear reactors. That's actually the thesis of a piece I wrote for the Ethereum Foundation a couple years ago entitled Kill Switch Protocols. And at the same time, I was editing a handbook in institutions and complexity theory. What do, the principles of indeterminate and highly uncertain systems teach us about rule choice to govern human people? That was redundant. Sorry. But the point being, that led me to be thinking, AI is coming, and boy, does it create an uncanny semblance of human responses when we query a generative AI algorithm. And in many instances, it does better than I can in terms of synthesizing available information in furtherance of a query I pose it. It's actually impressive. And boy, do I dork out on nearly every AI model, including agentic applications. This led me to be thinking, well, what about legal applications that we've been considering? And that resulted in this joint work that I'm going to present with you today with William Lair from MIT's Center for their Computer Science and Artificial Intelligence Laboratory. I think AI will be very productive in many legal contexts, including dispute resolution. But to preview my punchline, I do not think LLMs can perfectly substitute for human decision-making. And this follows nicely on Federico's kind of predictive conclusion. More on that in a moment. So judging is considered to be among the most essential public governance roles. And generally, you want to know somebody you're hiring, and certainly those exercising fundamental authority over you, you want them to have good judgment. And that's kind of a saying in English. He or she has good judgment. And so I, in rushing to get back here from lunch, ran across the street not in a crosswalk. The traffic wasn't moving. The fact that I didn't run into moving traffic, is that good judgment? No, I would call that just obvious. You wouldn't say he didn't run into moving traffic, ergo he has good judgment. The obvious decisions, the decisions we make that are an open and shut case, that is not good judgment. That is not the essence of human judgment. So what does it mean to exercise judgment? My contention to you here today is that it's in cases where the right answer is less clear, when it requires you to understand complex trade-offs where the extant information is actually insufficient to reach an overwhelmingly dispositive conclusion. So our piece explores what are called canonical hard cases in law that confront the courts with positive probability. And if you've studied law, you're familiar with the controversial statement that hard cases make good law. I'm not here to say that they per se result in generally applicable legal rules, which is the essence of the debate in legal scholarship as to whether these edge cases, these hard cases as they're called, result in more generalizable rules. What I am here to say is these cases emerge with positive probability in every single dispute resolution or just judgment-based human system, especially the courts. You've also, if you study law, heard the argument, all rules are over and under inclusive. What does that mean? It means that the messiness of human behavior as mapped to any ex ante specified rule will always there will be cases where somebody violates the rule and we don't want to punish them. Think of the husband speeding to get his pregnant wife with a serious medical complication to the hospital. Or think of somebody, driving not over the speed limit, but given conditions, say they're icy, say it's foggy, they are clearly behaving quite dangerously. That is an example of all rules that are ex ante specified, not perfectly capturing the human behavior that is subject to those rules. So there's this deeper intent underlying the rules we create that judges always, not always, but in certain cases, have to recursively consider in order to decide the case, as it were. And this means our entire legal system involves a tiered process with considerable filtering before a case actually ever reaches that essential application of judgment, as it were. Public and private defenders, they advise their clients to plead if the facts of the case are sufficiently certain. In civil cases, either the civil attorney won't take the case or they will advise their client to settle if they're on the opposing side, again, when the outcome is sufficiently clear. And so our entire legal system involves considerable filtering for the hardest cases relative to ones where the extant heft of information, the bulk of precedent, is itself clear. So how do LLMs decide? And yes, there's a bit of a black box here, and boy, have I been reading a lot to try to get up to speed on this. But it's funny how much the image generation algorithms, when I talk about AI deciding, populates this unnecessarily anthropomorphized image in front of you, the robot thinking. That is not what is happening. Fundamentally, it is not a human thinking long and pondering these ineffable questions. Instead, all the data, more data is better. Tokenize each object within a language model into constituent elements among which structural and relational patterns can be identified. And yes, synthetic data is possible. But to me, the synthetic data is recombinations of existing data. It can't sort of create that which doesn't exist. I'm not saying there isn't anything novel coming from LLMs, and certainly for chemical compounds, biological compounds, I think recombinatorial possibilities are exciting and transformative. And this talk is not anti-AI, coming to that in a few slides. But I think that there are fundamental limitations on the way in which these models rely on the extant heft of information and recombinatorial possibilities of that same information. So, to me, I'm arguing that they don't actually decide in the same way that humans decide in the cases of hard decisions. Instead, it's a recombinatorial assemblage of likely relationships between the empirical tokens that compose a given LLM's dataset. How do judges and juries decide? Does the law apply to the facts presented? If the law applies, do the facts presented result in a sufficient probability of guilt or liability or not? Does the case present constitutional issues that require reconciliation? That can be an attack on the law itself, saying this law is actually unconstitutional, so I was liable or guilty under it, but it's an unconstitutional law, and ergo I shouldn't be punished or found guilty. If the answers to all of these questions were knowable ex ante, we could fully automate the process. And my contention is the answers to all of these questions are not so knowable. They're revealed in real time by the messiness of human behavior as mapped to an ex ante specified set of rules. And legal institutions are designed to winnow toward cases where the answers to these questions are non-obvious. So hopefully by now it's apparent that I'm arguing adjudication, the human judgment element of adjudication, is confronting uncertainty. Ceteris paribus, the more the application of the law is clear to a given case, the more certain is guilt or innocence. The more the standard of proof has been reliably obtained or surpassed, the more certain is guilt or innocence, and the less a case presents constitutional ambiguities, the more certain is liability or guilt under a particular legal standard. But many people acting around one another create what we call a non-ergodic world. Setting aside the elements of our physical systems that are themselves not entirely determinate, boy, does the messiness of human intent, free will as it were, result in unpredictable outcomes vis-a-vis our ex ante foresight. This is called Knightian uncertainty or non-ergodicity in one of my favorite scholars' words, Douglas North. So the three classes of cases that we argue are just fundamentally empirically confounding are those of novelty, imprecision, and incommensurability. Completely new circumstances that raise the question of whether the intent of the law should apply in those new circumstances. And if you're struggling for purchase, I've got examples of each of these classes of cases in a moment. Imprecision. It's not a case whether a point estimate surpasses a particular standard of guilt or liability, but when the facts presented result in a very noisy point estimate. Sufficiently large confidence intervals around that point estimate, I also think present a problem in terms of dispositively concluding whether that standard has been surpassed. Finally, incommensurability. And the way I argue this is, I think King Solomon, the parable of King Solomon, is often wrongly construed as a sort of a pay-into mechanism design. To me, I'm not even sure the threat is credible to cut the baby in half. I don't want to live under any king that would actually credibly threaten to do that, although I recognize in times past such dictators certainly existed. Instead, it is a parable by my read about the fact that the hardest cases that come to our decision makers, those exercising authority over us, those hardest cases are ones where both things can't obtain. There is no compromise possible. One mother got the baby and the other one didn't. And to me, that is a parable about these essentially kind of incommensurable cases where two constitutional rights both cannot prevail at the same time. So some quick examples. When the Fourth Amendment was written, GPS trackers were nowhere near anyone's radar, pun I guess intended. The thing being is the GPS tracker on a car on a public road, is that a violation of the right to be free from unreasonable searches and seizures without the issuance of a warrant? This requires a recursive inquiry into what was the intent underlying the law and how do these completely new facts map to that intent. In the interest of time, second one, if you've taken torts classes, this is quite a famous case. Passenger rushing to make a train that's departing the station. The train employees help him get onto the train. In that helping him, unbeknownst to anyone but the passenger himself, a large packet of fireworks, very explosive fireworks, falls out of his pocket, blows up, knocks over some heavy equipment at the railroad station, and injures a passenger waiting for a different train. The fundamental essence of the inquiry was, could those railroad employees have reasonably foreseen the harm associated with their actions in helping this rushing passenger? And so again, it requires an inquiry into the facts don't clearly indicate what would be reasonable given the circumstances. After the fact, it's very clear, yes, it's seemingly reasonable to say a passenger might have explosives in their pocket. But before the fact, could they have reasonably foreseen that their actions in assisting this passenger would lead to the harm in question? Final case. This is a very recent one, and I do think I've been misinterpreted as saying I support Second Amendment rights as they're currently construed in the United States. I'm not making that contention. Instead, I'm saying this social value is deeply held among certain segments of U.S. society, and the Supreme Court takes that right very seriously. There's a gentleman in Texas who is subject to a restraining order due to threatening behavior towards his ex-girlfriend. Part of the restraining order enjoins him from possessing firearms. Problem is people accused of threatening or abusing their spouses, not all of them are ultimately found guilty of that same crime. And so any restraining order that takes away their gun rights takes away the rights of somebody eventually exonerated. Problem is, many of the people who are accused of battering their spouses that own guns then go home and kill their spouse or injure them severely with those same guns. These are two social rights that cannot both obtain at the same time. This requires an inquiry into, I argue, deeper values. I could put a numerical value on either countervailing right here, and it should sound a little bit offensive, meaning we know demand for guns, we know how much guns cost, we even know the specific guns that the individuals subject to these restraining orders own. And that creates a numerical value, and guess what? For public policy purposes, we have a variety of ways of calculating the statistical value of life. So we can also say this many spouses accusing their, partner of battering them, and this many are killed as a result of this. And we could weigh those two numbers off one another. And I sure hope that is not what judges are doing when they're deciding which one of these rights is more important. So we do think AI will improve adjudication, although not in the robot-wearing judicial robes, and our constant tendency to anthropomorphize the outputs of these generative models. Instead, we think it'll improve adjudication and therefore human decision-making more generally. Being able to better collate and synthesize the bulk of information relevant to deciding a given case should reduce the number of hard cases on the margin and thus be a very productive complement to adjudication. Second, those judges, and we are not arguing that human judges are free of their own biases. Far from it. But if an LLM generates a sufficiently dispositive conclusion and the judge departs radically from it, that will be part of an evidentiary, set that goes up in a level in appeals. And so we think actually the presence of using LLMs to synthesize relevant case information will reduce the number of hard cases, but also constrain judges in terms of their own biases as and where they appear. And finally, despite the beneficial applications that we think LLMs will have in a variety of legal contexts, and our earlier speaker alluded to some of those very interesting cases, we think these models will never perfectly substitute for human judgment. And so we view a synthesis between the two as being essential, and that's something I've long thought was really cool about Kleros, which is how do we embed humans in the machine and productively constrain each side's deficiencies, as it were. But this matters for more than the law. Judgment matters for more than judges, and is arguably a principal input to human decisions more generally. Which decisions? Not the easiest and obvious ones, not the easy and obvious ones, but ones fundamentally governed by uncertainty. This reveals a margin by which hard decisions are unavoidably political precisely because the objective answer isn't sufficiently defined by available information. So understanding hard cases can reveal limitations of AI applications in human decisional contexts writ large. So in sum, the greater the uncertainty, the less extant empirical evidence guides us about how to proceed, the less generative AI will be a complete substitute for human decision making. Thanks for your attention.
Okay, good afternoon, everyone. It's a pleasure to be here today and to be part of this panel. So I find myself in somewhat an unusual position with one foot firmly planted in the world of traditional dispute resolution as an associate director of Dialis, and the other in decentralized justice as a member of Kleros' supervisory board. It's a bit like being bilingual in two very different languages, and believe me, sometimes traditional arbitrators and blockchain developers really do seem to be speaking entirely different languages. So this dual citizenship, if you will, has given me a unique vantage point from which I observe how AI is transforming both worlds, and perhaps more importantly, where these worlds might converge. And, that's what I'd like to explore with you here today. It's not just how AI is changing each domain separately, but how it might help build bridges between them. So let's start with what's happening in traditional ADR, a field that, contrary to popular belief, isn't entirely resistant to technological change. The truth is, AI has already begun transforming traditional dispute resolution in ways that might surprise you. Document analysis systems are now standard in complex commercial arbitrations. I recently worked on a construction dispute involving over 500,000 documents, which is a volume that would have required an army of junior lawyers probably 5 years ago. And today AI tools have identified the most relevant 0.5% of documents in days and not months. Predictive analytics, they're also making inroads. Some firms now use these tools to forecast arbitral outcomes and case specifics. As a traditional ADR practitioner, I admit, my first reaction was skepticism. An algorithm can't replace my years of experience. But the data is increasingly compelling. And, in one study, an AI system predicted arbitration outcomes with 71% accuracy, marginally better than a panel of experienced practitioners. So case management platforms are also perhaps the most widely adopted AI application, streamlining everything from document sharing to hearing scheduling. What's remarkable isn't just the efficiency gain, but how quickly these tools have become expected rather than anything else. However, traditional ADR faces a significant constraints in AI adoption. Institutional conservatism, concerns about confidentiality, and the weight of established practice all slow down its implementation. And let's be honest, some of us in the traditional practice harbour concerns what these changes might mean for our profession. As one senior arbitrator sort of said to me recently that, I didn't spend 40 years mastering this craft to be outperformed by ChatGPT. So meanwhile, client expectations are evolving rapidly. A generation raised on one-click shopping and instant digital services increasingly questions, why can't dispute resolution be faster? Why should it be taking, years and cost millions? This expectation gap creates both pressure and opportunity for innovation. The most exciting developments, in my view, are happening at the intersection of traditional and decentralized approaches. And this is where my experience with the mediation bridge that was mentioned earlier concept comes in. For those unfamiliar, the mediation bridge is a hybrid model that Federico and I developed, which combines traditional mediation with blockchain-based arbitration. And the concept is fairly straightforward. It's the use of human mediators for what they do best, facilitating communication, building rapport, exploring interests, and the use of the decentralized systems like Kleros for what they excel at, which is making, clearer decisions in potentially binary formats. So this led to the development of Harmony, which is an AI mediator designed to guide parties through the hybrid process. And, Harmony wasn't designed to replace human mediators, but it was designed rather to handle specific structural aspects of mediation, organizing issues, documenting positions, identifying areas of agreement, while preparing, unresolvable issues for potential blockchain arbitration. Our real-world experiments with this model have yielded some fascinating insights. So firstly, integration points between human-led processes and, algorithmic ones are far more complex than what we'd anticipated. It's not simply a matter of passing a dispute from one system to another. The systems need to understand, each other's language, so to speak. And second, traditional ADR principles like confidentiality, party autonomy, and procedural fairness remain essential, even in AI-enhanced systems. These principles aren't obstacles to innovation, but rather crucial design requirements. And third, successful integrations requires attention to the transition points, so creating clear expectations and smooth handoffs, which proves crucial. And perhaps most importantly, effective integration isn't about replacing human judgment, but it's extending it. So creating systems where human mediators and AI tools each handle what they do best. So this brings me to a critical question. What happens to human dispute resolvers in an AI-based system? So, despite the dire predictions, I also don't believe that we're witnessing, the end of the human mediators and arbitrators. Rather, I think we're seeing an evolution in their role. So, the next generation of dispute professionals won't be replaced by AI necessarily, but they'll probably be supercharged by it. In my experience implementing these hybrid systems, the most successful human practitioners are those who view AI as extending their capabilities rather than threatening their existence. They use AI to handle routine tasks, analyze vast document sets, identify patterns, manage logistics, freeing their human bandwidth for the aspects of the dispute that resolve, emotional intelligence, creativity, ethical judgment. And this shift this shift demands the new skills. So tomorrow's dispute resolution professionals need technical literacy, systems thinking, design sensibility, alongside traditional legal and negotiation skills. As one of my colleagues put it, we need to be conductors of an orchestra of tools, not just soloists. So ethical considerations become more important in this context. In traditional ADR, ethical frameworks are well established, if not always perfectly implemented. In AI-enhanced systems, these frameworks must evolve to address questions like who's accountable for AI-generated recommendations, how do we ensure algorithmic fairness across diverse cultural contexts, how do we maintain confidentiality in systems that learn from all this aggregated data. But yeah, what excites me is the most untapped potential of what I call augmented dispute resolution, which is systems where human judgment is enhanced rather than replaced by technology. So imagine a mediator with real-time access to sentiment analysis of party statements, prediction models for likely settlement zones, and automated drafting of agreement terms. This isn't science fiction; it's already happening. In small pockets of innovation around the world. So looking ahead, I see several critical challenges where we must address and realise the potential of AI in dispute resolution. I think first we need better standards for assessing AI tools in dispute contexts. Without clear evaluation frameworks, adoption will be haphazard and potentially harmful. Second, we need regulatory frameworks that enable innovation while protecting core values like fairness, autonomy, and accessibility. This isn't just what's technologically possible, but it's what's socially desirable. And third, we need education and training that prepares both current and future practitioners for an AI-enhanced landscape. This includes technical literacy and also a deeper understanding of how to integrate human and machine capabilities effectively. I envisage a future of multi-layered dispute systems that seamlessly combine human judgment and AI capabilities. And in this future, disputes might begin with fully automated processes like we demonstrated earlier for standard issues, and then potentially escalate to AI-assisted human mediation for more complex matters and reach traditional arbitration only when truly necessary. The boundaries between traditional and decentralized approaches would become increasingly closer, and with each learning from one another. And traditional institutions and decentralized platforms won't merely coexist, they'll collaborate. So we're already seeing this with arbitral institutions exploring blockchain for document verification and award enforcement, while decentralized platforms like Kleros are incorporating traditional ADR principles into their design. So my personal vision is one where AI doesn't just make dispute resolution faster or cheaper, but it fundamentally makes it more accessible and just. Technology that merely replicates existing power dynamics fails to achieve its potential. The real promise lies in systems that democratize access to effective dispute resolution, making justice available not to just those who can afford it, but to everyone. I'm increasingly convinced that building these bridges isn't just possible, it's essential, and I hope that some of you join me in this work. Thank you.
We have only like 4 minutes. So I will ask you the same question I asked Colin to see, because this is, I find this very interesting and important. Would people accept decisions done by AIs?
I think it's an evolution. I think from the get-go, perhaps not, but in time they will. I think as people become more aware of their reasoning capabilities and their ability to actually do things successfully, that they're more likely to accept this process. But I don't think necessarily that will be happening, in the next few months. I think it will probably take quite some time. It will intrinsically be linked to how these things become smarter, if and when we achieve AGI or ASI, and it's more common knowledge that they are smarter than us, then yeah, I think people will accept the decision. But if their decisions are based on ambiguous processes, and there's still a hallucination problem, and various things like this in their current form. I think we're still a bit away from people widely accepting them.
On that same question, I mean, I think it's a fascinating one, and there's a sort of truism, which is the appearance of corruption can be damaging as corruption itself. Am I saying AI is corrupt? No, but I'm saying the appearance of a system enforcing law matters as much as the actual substance of what's happening. And so I do think that a level of socialization and becoming more familiar with the capabilities of AI, including on certain margins, far more intelligent, I think that'll be part of the process. But I worry about, I see two possible futures. And I've seen, people lauded in the UK who systematically go and tape over or destroy cameras. And so, to me, a deep question for our entire society surrounds what level of privacy we enjoy in future periods. Because if we can record all of our behavior in every moment, boy, will LLMs make great decisions about whether our behavior was guilty or not in a particular moment. But that also happens to be a world I do not want to live in, where we don't have a sphere of autonomy. If we have a sphere of autonomy that is not legible to third-party observers who are not present in a given moment, that will create a penumbra of uncertainty about what actually happened in a particular circumstance when two people got angry with one another, you name it. And so for me, that will still create some measure of uncertainty about what behavior actually occurred. And so I prefer that world, but that's probably one where we still have some form of human judgment in some stage of that process. And again, I'm not anti-AI. This talk has been received, mine as very anti-AI, and I'm trying to temper that. I'm like productive complement and constraint, but not perfect substitute. That's my punchline.
Well, we have run out of time, unfortunately. We can discuss this in the coffee break later because we already have our next speakers here. So thank you very much, and let's move to the next panel. Thank you.
Thank you.